In a San Jose federal courtroom, a local case with nationwide implications. A policy implemented by the Department of Justice this year allows ICE to detain people who have not been determined to be a danger to the community at check-in appointments and at immigration court. A new federal class action lawsuit against U.S. Secretary of Homeland Security Kristi Noem and the DOJ seeks to end this policy. Bree Bernwanger, a senior staff attorney with the ACLU of Northern California, says the case of Fresia Garo-Pinchi is an example of why that policy is problematic.
It's about what ICE, what police can do, and why they can throw someone into jail. We have all seen the images of ICE agents going into immigration courts and grabbing people out of their families' arms for no reason. That is something that should concern us all.
Garo-Pinchi is a Hayward resident who left Peru and is seeking asylum based on her sexuality. In July, she was detained while attending her immigration court hearing in San Francisco. After filing a petition for her arrest, Bernwanger said the government was asked by U.S. federal court judge Casey Pitts what reason they had to detain Garo-Pinchi.
They said nothing. We just think we have discretion to detain her. That explains what they have been doing when they sweep people up who are following the rules and complying with the law, and that's what has to stop.
Tuesday in U.S. federal court in San Jose, the government justified their position. The DOJ did not provide a formal comment after the hearing despite our request, but during court, their lawyers said arrest is part of the risk of being here illegally, and that laws on detention give them the ability to detain at their discretion. Jordan Wells is a senior staff attorney at the Lawyers Committee for Civil Rights of the San Francisco Bay Area. He argued this presents a catch-22, offering immigrants and asylum seekers the choice of giving up an immigration case or giving up their freedom.
It's not that ICE can never do this. It's that they have to have a policy that's well-reasoned. And, you know, as with so many of the policies under this administration, like they declare an emergency or they declare an evasion and they just start moving fast and breaking stuff.
The ACLU formally requested to pause this policy while the lawsuit plays out in court.
Judge Casey Pitts will mull over the arguments made during this hearing. While he says there is some urgency to this matter, a final decision may take several weeks.